Lovely. Right, evening everybody. My name is Joe Brightman. I'm a solicitor with Ellisons Solicitors. Always conscious when you come to these sorts of events and you're asking for a solicitor to talk about something that's interesting and helpful to all you buy-to-let landlords. You've got an accountant who's telling you financial, useful tips. You've got someone talking about the market locally, which is very helpful. Solicitor comes on there and starts talking about legal issues which aren't terribly interesting. What I've tried to do is talk about some tips you'll have, so practically you'll go with a couple of tips from it, and also you'll know where, so in terms of the buy-to-let market, the legal landscape is going sort of at the moment, and the trends over the last sort of few years. So it's called AST's Traps and Trends. That's my part of the talk. We've got a short introduction about Ellisons. They're a law firm established over 250 years ago. Offices in Colchester, Ipswich, tendering, and most recently through the doors there in Chelmsford a couple of months ago. We're a full-service law firm. I have lawyers specialising in all the usual areas of practice, and all listed on our roller banner there. I've also got a financial planning side to the business as well. I'm personally part of a department of specialist lawyers dealing with property disputes, so that does include possession proceedings, so when you need to evict tenants for whatever reason. Most of you will know the only way of doing that is by making application to court to get a possession order. In terms of a general outline, I'm going to talk about the theme really is increased regulation, and that's the sort of clear trend that we're seeing in terms of the legal landscape when we're talking about the buy-to-let market. So I'll talk about that, the history up to date, so you can get a flavour of what's been going on in the legal sort of landscape. I've given two sort of practical examples. One is if you've got a tenant who falls into rent arrears, and the second example is talking about disrepair and how that's a very directly has an effect on you as a landlord and your ability to recover possession. I've tried to conclude, it's always difficult to predict exactly what's going to happen in the future, but I've tried to give you sort of my thoughts as to what is going to happen in the future in terms of legal landscape for short-term let. So Chris mentioned ASTs, which was a type of residential tenancy. It's an assured short-hold tenancy, and there's a legal definition to that, which is where a property is let to individuals, not to companies, and the tenant, or at least one of the joint tenants, occupies the property as their only or their principal home, and that we're talking about ASTs and the parts of the talk that will follow. It's the type of residential tenancy which gives the least security to an occupier, and it's at its most basic analysis, a landlord simply needs to serve a 2-month notice to quit. That's the Section 21 notice. So in terms of the key sort of legal trends to date, pre-January 1989, Chris again touched on this, you've got this concept of Rent Act tenancies, where it's very difficult to evict tenants. 15th of January 1989, it first becomes possible to create an assured tenancy and also an AST. Assured tenancies were slightly more difficult, but easier to evict tenants than Rent Act tenancies. In February 97, ASTs became the default residential tenancy, and that remains the position now. Up until 6th of April 2007, in order to evict the tenant, you simply needed to serve your Section 21 notice and then apply to court for a possession order. From that date onwards, this obligation was introduced whereby landlords had to protect tenancy deposits paid by tenants as security against their obligations during the tenancy. A failure to protect the deposit would have prevented the landlord from serving a Section 21 notice, and the landlord becomes liable for a financial penalty. A few years ago now, October 2015, more regulation was brought in, slightly oddly brought in under what's called the Deregulation Act, so brought in more regulation under that name, and additional conditions were brought in before the landlord could serve a valid Section 21 notice. That was serving the EPC, the government issued brochure called a How to Rent Guide, and also serving a gas safety certificate. It brought in this concept of retaliatory evictions, which is we'll talk about it when we're talking about disrepair, but it's where landlords are prevented from evicting a tenant where the tenant's complained about the condition of the property. It brought in a prescribed form of Section 21 notice, And there's also a time limit as well on the validity of a notice. You had to use it within a certain amount of time or it would become redundant. You had to reserve the notice. On the same date, there was also an obligation to install smoke and carbon monoxide alarms to the property. Again, if you didn't comply, there would be a financial penalty.